for those of you who are joining us from Japan, and good morning to our friends from Europe. My name is Arthur Mitchell, and I'm going to moderate today's session. 3 years ago this month, Henry Kissinger wrote a very interesting article in the Atlantic magazine called How the Enlightenment Ends. And he had some very interesting observations about AI. He said, information is threatening wisdom. The emphasis on speed inhibits reflection. AI systems are inherently unstable. They're always analyzing data. Explainability is a key issue, which is difficult to overcome. Very surprisingly, he said, we must expect AI to make mistakes faster and of greater magnitude than humans do. Then he set forth a couple of questions. One, how is consciousness to be defined in a world of machines that reduce human experience to mathematical data interpreted by their own memories? Who is responsible for the actions of AI? How should liability be determined for their mistakes? Can a legal system be designed by humans in a way to keep up with the activities produced by AI, which is capable of outthinking and potentially outmaneuvering people? I think the proposed EU regulation is an attempt to deal with these questions. So I would like to introduce our panelists at this stage. I'm Arthur Mitchell, Senior Advisor in the Tokyo office of White & Case. We have Bertrand from our Paris office. He's a partner who specializes in intellectual property, but also deals with important matters related to regulation in the EU. Toshio Dokei is the administrative partner of our Tokyo office and is a specialist on finance and antitrust matters. David Albagli is a partner in the Tokyo office, specializes in intellectual property, and is also very actively involved in regulatory matters in a cross-border way. Today we also have a very important guest speaker, Kenneth Cukier, a personal friend from many years ago. Ken is the senior editor in The Economist, who's written a number of books on big data, AI, and most recently a book called Framers, which I read from cover to cover and really had trouble putting it down. So we're going to be very interested in hearing his discussion and comments. So now I would like to try to frame the discussion by talking about why it's important for all of you to be concerned about regulation in Europe. First of all, this regulation will cover anyone who's making an AI product or service when it's put into operation in the EU, even if it's made outside of the EU, including Japan. All of these AI systems, which were created prior to the effectiveness of the regulation, it's not effective right now, it's just a proposal, but some years down the line when it becomes a law, the products that you're working on today will have to be brought into conformity in many respects, particularly the high-risk one. This is the same approach that was taken with GDPR, and we're going to talk a little bit about the nexus of these two regimes. Also, there will be some serious penalties for violation of the regulation. In the worst case, it could be as much as 30 million euro or 6% of global turnover. Enforcement is going to take place on a country-by-country basis. Unlike GDPR, there won't be a one-stop shop for the moment. That's the way they plan to do it. And in addition to those administrative penalties, which can be imposed by the European Commission, individual states can also provide for compensation in the event of liability. So this is a very serious regulation. We do think it's going to take a little time. There is time to provide comments, and many companies are doing that. But we think it's pretty certain that this will become a hard law, if you will. And so what we want to do today is try to give you really the broad outlines of what you need to think about and what you need to think about today in order to, in some ways, be able to position your products and services in a way that will not cause undue concern for yourself or for your customers and clients. So with that, I'd like to ask Bertrand to talk about some of the key concepts that we need to keep in mind while we're thinking about these issues. Bertrand, over to you.
Thank you, Arthur, good morning, everyone, and good afternoon for those for which the afternoon has started. So my task here is to deal with or present you the key concept of this new piece of legislation, at least, or draft legislation. And just as a reminder, the legislation is quite recent. It was proposed on April 21st of this year, and it's going to take around 2 years to become a law, a regulation as part of EU law, and it probably is going to say that people will have 2 years to implement everything. So we are at least 4 years down the line, but we have already started advising our clients, navigating the complexities of this regulation, because it is a complex regulation. It is no less than 132 pages, 89 recitals, 85 articles, and 9 annexes. So it is a big piece of legislation and quite complex. Next slide, please. So first, to start with a few definitions, which set the scope for the regulation, the draft regulation. So first of all, what is, according to the Commission, an artificial intelligence system? It is a software that is developed with one or more of the techniques and approaches listed in Annex 1, and can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions, influencing the environments they interact with. So it's first, this regulation deals with AI system, and not just AI in general, but AI systems. But still, it means systems, AI or pieces of software which are either embedded or not embedded in devices. So it's either the kind of software program that you can use on a website, but it's also software that is embedded in devices such as robots, medical devices, etc. What is important also to note is that it's not every kind of software. It's pieces of software that are defined by reference to using techniques listed in Annex 1 of the regulation. And importantly, this Annex 1 is drafted, so it includes techniques such as machine learning, including deep learning, logic and knowledge-based approaches, and statistical approaches. So these are the techniques today that define artificial intelligence according to the draft regulation. But that can be changed by the Commission further down the line to adapt to the techniques that will be developed by the market. Key definitions as well, provider and users. The provider is a natural person, is a natural or legal person, public authority, agency or body that develops the AI system, or ask someone to develop an AI system with a view to placing it on the market or putting it into service under its own name or trademark. So really the provider is really key to the definition and to the regulation. It's the person who puts the AI system on the market, and that's the provider that will bear the most regulatory burden, compliance burden. And the user is also is the person that just uses that kind of system, with an exception where the user is using the system in the course of a personal non-professional activity. And what's important for that is that you have the provider. So imagine there's a technique or a piece of software, a device. There is someone that's using it and using it for someone else, right? Sort of the because the regulation covers B2B as well as B2C, or what we call now also platform to business, and all the relationship are covered through this definition. The regulation adopts a risk-based regulation. So next slide, please. And that's really what's really important to understand this regulation is that it takes the view that it really is a risk-based regulation. So there are issues that are not covered into the regulation, but the regulation says whenever you will put an AI system on the market, you will need to make sure that the risk and the safety of the user is ensured, and that's really key, a key concept of the regulation. So first of all, there are applications or AI systems which are not acceptable, and there's the one who creates a risk of damage to fundamental rights, to the people, to the human species, if you will. And that includes systems such as social scoring, facial recognition, dark pattern AI manipulation, and the like. Interestingly, this system, which create an unacceptable risk, are prohibited under Article 5 of the draft regulation, and then include, for example, systems that deploy subliminal techniques beyond the person consciousness in order to materially distort a person's behavior in a manner that causes or is likely to cause that person or another person physical or psychological harm. So it's really important to take each word and read it and see how that will be construed by the regulators, so that the systems that are currently in use or are currently being developed do not fall within that definition. And there's a list in Article 5 of 4 or 5 applications which creates unacceptable risk to the fundamental rights, and that will be prohibited. There are also high-risk AI systems, and I will come back to that, and they cover issues such as or applications such as education, employment, justice, immigration, law enforcement, etc. And these high-risk systems, they need to go through a conformity assessment. So very similar in fact, and that as what is currently the regulatory framework that is currently applicable in Europe when you want to put a device on the market which creates a risk of safety to people. So, the brakes for cars, for example, it's exactly the same, right? That create a risk of safety for the people, bodily or physical harm, and then they need to go through a conformity, etc. And we will come back a little bit on that. Here, the main difference is that there still can be sort of a physical harm because there is a device and the AI system is included in a device, or it could be purely digital in the digital world, and it's harm that is a little bit more difficult to handle and to apprehend. Apart from that, there are also limited risk AI system, so which we know today, such as chatbots, deepfakes to a certain extent, emotion recognition system, etc. And these are of limited risk, and then the regulatory obligation will be mainly to ensure transparency, and so explain to the users what type of system are being used. Finally, there are also minimal risk AI systems, and those are like spam filters, video games, and that will be only covered by code of conduct. So if we can move to next slide, please. So high-risk AI system. High-risk AI systems are defined in Article 6, are already as twofold. There's one definition which says whenever it's included in a device that is already covered by a safety regulation within the EU, then that is an AI system that is high risk. And that covers already a lot of regulation. So whenever, so if you're familiar with the CE marking systems, basically, so it's a safety regulatory framework already applicable. And so if you're putting toys on the market, if you're putting medical devices on the market in EU, if you're putting that kind of product, so for airplane, for motor vehicles, for you know, a lot of you know, airspace, lifts, etc. So all of that creates a risk of safety for human beings, and that will be included whenever they include AI system. That will be also subject to the regulation. Another important list of high-risk system is the one that are standalone, so not already included in that type of definition or not included in a device, but may have or will have fundamental rights implication, and that's the one listed in Annex 3 of the draft regulation. And that is very important for, you know, many businesses, because also Annex 3 covers applications and systems which are, I would say, mainly aimed at governments and public bodies. Some of them are really you know, targeted or are of interest for businesses. So and we will see when we see that through the use case we will discuss later on. So Annex 3 covers and says that, you know, high-risk systems are include applications such as, or areas such as biometric identification and categorization of natural persons, management and operation of critical infrastructure, education and vocational training, employment, workers' management and access to self-employment, access to and enjoyment of essential private services and public services and benefits, including evaluation of the credit worthiness of natural or credit scoring of natural persons, law enforcement, the migration, asylum and border control management, and administration of justice and democratic processes. There's a lot of applications behind that, and a lot of fine-tuning on whether, you know, any of the systems that the companies and our clients are developing will be either included because they are included in the list of devices which are already covered by safety regulation in Europe, or whether they fall within any of the categories that I've just described. And, you know, credit worthiness, you know, identification of person, that's really something which is quite common actually in the systems that we all use and we all develop today. The obligations that goes with the qualification of high-risk AI system is what you can see here on the slide. So the provider needs to use high-quality training, validation, and testing data. So there's really first, you know, the data on which the AI system is based must be cleared and high quality, and then there must be, you know, a lot of technical documentation put in place, ensure transparency for users. A key issue, I think, is to ensure human oversight to prevent or minimize the risk to health, safety or fundamental rights. And that means that all the systems must be designed so that at any point or at some point, a human can oversight, human beings can oversight what's the outputs of the system, and of course, ensure robustness, accuracy, and cybersecurity. Whenever you're developing a high-risk AI system, you will be bound to register that in a EU register, and that will be really the place where the authorities can track what has been put on the market and ensure enforcement of the regulation. Next slide, please. So the way the regulation works is really again, it's really similar to the safety regulation that we can see in other areas. So before, and that's really important, it's before putting an AI system on the market, a high-risk AI system on the market, the provider will need to run a conformity assessment. And that conformity assessment, of course, shall be positive in the sense that, fundamental rights and the risk identified in the regulations are properly addressed through the controls and the systems put in place and the conformity system put in place. Once the device or the system is on the market, then there will be, of course, a post-market monitoring. So the provider must be sure through either directly or through the users or the end users to make sure that they collect data so that the use of the system remains compliant with the regulatory framework. Of course, an incident report system to make sure that any malfunction is identified and reported. And whenever there's a change, a major change in the system, and of course there will be important debate about what's a major change in the system, then the need will rise for a new conformity assessment and back again to the life cycle of regulatory compliance. So that's in very broad and general and in shorter time than needed, a few key concepts of this regulation. It's a very complex piece of legislation, and every word has an importance. And this is going to happen, so everybody needs to prepare to that. Arthur?
Okay, Bertrand, thank you for that very concise overview. Now I'd like to have David introduce some case studies, and I want to mention why we're doing this. It's one thing to look at the regulation in the abstract, but we're going to try to make it very concrete by taking a few actual cases. And in fact, many of you, we know that many of you are actually working on some of these types of systems today. Now, the facts in our case studies are very broad, and you'll see that a very detailed factual analysis is required because part of your intention in putting a product or a system on the market is very important, and then how it is actually implemented. And it, even though, as Bertrand explained, there are various risk categories: prohibited, high risk, minimal, or limited, and then minimal. Sometimes it's not all that easy to determine exactly which category your AI system falls into. So let's, David, why don't you start with that, and then the White and Case folks will comment accordingly.
All right, thank you, Arthur. And good afternoon and good morning to all of you who have joined us today. As Arthur said, we'd like to try to make this discussion a little bit more concrete. And again, we've looked around to see what types of products are in the offing. There's a lot of activity in this area. And so without further ado, if I could have the next slide, and just to put out on the table the idea of how would we analyze the type of risk profiling and the type of steps that would need to be taken by a company developing AI systems if they were doing the following. So in this first case, we've posited that a company would be developing cameras and software that would go to analyze the images to, for example, on the left side of the screen here, count the number of people in a crowd. So a crowd counting technology. We know that there are cameras used all throughout the public. There are various uses and applications, but in this case, we're thinking about crowd counting, which does mean discerning whether we're actually looking at a person or some other object on the side of the road. So there has to be some element of facial recognition, probably, or body motion that's happening. In addition to this, we posit that this manufacturing company or this technology company that makes this device may also be automating and monitoring its workplace. So, or rather, in the manufacturing area. And so this company may also be selling software that would allow companies to monitor all aspects of its manufacturing process. And we can get into the facts that might change the scenario in this case. And third, perhaps this company also is looking to introduce into the workplace wearable devices, such that all the employees working at these machines are also being monitored. And that could be done through a wristwatch. It could be done through other elements, various other products that we know are under development. So taking all these various aspects of the use case, let's ask the question: Are these going to be even perhaps forbidden technologies, or would they be high-risk technologies, or is there a way that under some circumstances they might be limited risk and therefore not be as highly regulated and requiring of clearance measures? With that, Bertrand, if I could throw this question to you. The crowd counting technology, suppose it's just looking at, say, the human form without picking out identities. What do you think?
Yeah, thanks, David. So yeah, a couple of comments on the crowd counting technology. So we are all aware that there's a risk, or at least we need to make sure, or the provider needs to make sure that they're not touching upon the prohibited activity of using real-time remote biometric identification system in publicly accessible space for the purpose of law enforcement. So really, it really depends, and you need to go down on the technique to make sure that the technique or the technology is or is not using real-time remote biometric identification. It doesn't mean that you cannot develop such technologies. It just means that whenever you're using it for law enforcement, and there are certain a lot of precautions, additional precautions to be made. So that's very important as a provider to understand what your user will be able to do that, and the user in that case would be like a law enforcement agency, for example. On the other hand, even if there's no real-time remote biometric identification, the technology, I think one of the main issue is lies with the overlap between this draft regulation and GDPR. And the reason for that is because basically, in my view at least, and it really depends on how the technology works again, but in my view, whenever you're trying to count a crowd, then you need to make sure that you're not counting a person twice. And whenever you're sort of using an image of this person, whether it is fine or not, but fine enough to make sure you're not counting the same person twice, there is a risk, and I'm not saying that's 100% sure, but there is a risk that that data itself is personal data. And the way they both, and whenever there's personal data, then you will need to apply GDPR. So, and if you go to France and you're using that kind of techniques, there's a clear decision of the French data protection authorities back in 2017, which says, well, you can't do that because it violates the freedoms to freely go on public places, or at least you cannot use that in public spaces. And just another comment on that. So there's an overlap, clearly, or it's not really an overlap. It's just that both regulations will apply simultaneously, right? So there's the AI system, and then you need to address the risk, and that will be probably a high-risk system as well. So you need to do the conformity assessment, and you also, whenever there's personal data, you will also need to go through, the compliance steps of GDPR. So, for example, do also a privacy assessment in this case, and that's a sort of a slightly or very, yeah, it's a different exercise. That's
mm-hmm. Right. No, thanks for bringing up GDPR. I think it's a definitely a reminder that the regulatory laws are going to probably overlap in many of these situations. I think maybe perhaps later on we'll touch upon pharma industry, and there too there's a separate regulatory law that's probably going to overlap in certain products here. Yeah, let me shift to the factory floor, where I mentioned the manufacturing processes would be monitored, and presumably with the use of AI to be made more efficient. Now, if these processes are literally only happening within the company, not affecting the public at large, are there risks involved? Could this be a high-risk situation?
Yeah, I still think that there's a risk, or possibility that it is still a high-risk system. So one of the objectives of the first presentation was to show that many systems will be high risk, and any system dealing with employee, because employment is listed in Annex 3, is very likely to become to be a high risk system. So yes, there is a risk. So it's still possible that, for example, if it's only and specifically not creating any risk for the safety of human beings, and not allowing the company to monitor what their employees are doing, which is clearly the case when about the wearable devices. But it's still possible that the monitoring of the manufacturing processes doesn't allow, because of the way it is set, doesn't allow the company to monitor what their employees are doing, right? So because it's a fully automated process, for example. So it's still possible that this piece of software will not be high risk, because they will not be touching upon employees, and that's really the key thing to see here. When I look at the pictures, I see in any case that it's there's big robots, and so there are safety elements to that. So the software, whenever they will be using the type of techniques such as deep learning, statistical analysis, so the techniques that are listed in Annex 2, and they are embedded in that type of robots, the robot arm, and there's a risk for human safety. So that placed on the European market will be a high-risk system, most probably, and then we'll need to go through the regulatory framework and steps, compliance steps that I've described earlier.
Right, exactly. So safety can be the trigger point that brings us into a high-risk scenario. And I guess it's easy enough to think about robots that don't necessarily monitor the employee's performance, but sort of to bring that point into the discussion, we added the possibility of workers with wearable devices, perhaps on the wrist, perhaps through eyeglasses. But I guess here too, I could imagine it could be used to look at worker safety, in the sense of, are they tired? Is there too much stress or strain? But also I can see it used, for example, with respect to employee performance through the HR function of, is this employee a good employee? Any comments with respect to this?
Well, whenever the systems will be used to monitor performance, that will clearly put the system in the category of high-risk AI system. That's full stop. Also, because it's employees, there will be personal data. So we come back to GDPR issues, which means you need to inform the employees. You need to maybe do a privacy assessment, depending on whether it's considered high risk or not in terms of privacy. And you need to apply the full set of GDPR principles, including minimization of data. So we've seen issues with that type of systems where the wearable device must be shut off when the worker is not working, right? So when you're using wearable shoes or wearable watches, then it shouldn't invade your privacy or the privacy of the workers. So all of that will need to be taken into account before putting that on the market. Yes.
Right. Well, okay. Let's move to the next one. Next slide, please. And here in this case, we're thinking about websites and online stores and shopping and the like, where a website might analyze the customer's browsing habits. It might customize or personalize the content of the web page to the browser to the person based upon their browsing habits. And it may also recommend products. I think these are the types of actions taken by websites that we are all now very, very used to. So although these are for the most part, existing technologies, perhaps with some degree of AI already embedded in them, what type of situation do they face with this new proposed AI regulation?
So a key element or a key issue to analyze here is whether sort of this behavioral device or software would fall into the prohibited use of subliminal techniques covered by Article 5. I don't think that's the case, because here we are really only in a digital world, and Article 5 prohibits the use of subliminal techniques, but only when that is likely to cause the person, so the user, physical or psychological harm. So there must be a link with the physical world. So the psychological harm is probably a little bit more debatable, but it's probably unlikely that it will be prohibited. Now, just need to look at whether it is a high risk or not. So because it's not device based, it's a standalone system. Then the question is whether they are using they fall within the categories referred to in Annex 3. Here it's a tricky question. It really depends on the system itself, and whether by use of the system there might be discrimination or bias that are embedded in the systems, and that will create that is of course prohibited, and that will create a risk of falling into the category of high risk system, right? So that's what I would say to this case.
Right. Yeah. No. Thank you. And I guess I'll also point out this could lead to, or it could be related to concerns about dynamic pricing and other types of behavior through the website. I'll leave that point floating there. Maybe we'll pick it up later from Dokei-san or through questions. And let's go to the last case, number 3, please. And here we're positing that we may have a company that sells AI-driven software for credit scoring, or perhaps for fraud detection, or assessing risk, particularly with respect to financial transactions. Any quick word on where this might lie?
Yeah, so credit scoring is clearly a high-risk application. So it's the evaluation of the creditworthiness of natural person, or establishing their credit score is clearly set out in Annex 3 of the draft regulation. So it will have to follow the full compliance regime of high-risk systems. One maybe just one additional comment on that. So AI system needs to be regulated by humans, and there's a debate around that, around the creditworthiness, or whether there could be automatic decisions or not, based on the use of such kind of system for creditworthiness, right? So for example, it is clearly prohibited in France, and that's based on the privacy regulation. So the French, let's say the French application law of GDPR. It's a little bit less clear under the GDPR, or whether that's prohibited or authorized or not. But that's the type of questions that will need to be sought out, given the compliance regime of that draft regulation of the AI regulation, and then GDPR. So that's really not an easy one. The fraud detection, I would say there's less risk. Less risk because it doesn't fall clearly in one of the high risk definitions. So we'll probably be more into the medium risk category, so to speak, which will need to for which the provider and the user will need to provide more information and have transparency obligations. But it depends on the type of data there, which will be used, whether it's based on for example, the behavior of specific individuals, and then GDPR would come into play, or whether it is sort of purely looking at unusual transactions sort of analysis. Risk assessment, probably the same, but also here the main issue will be to make sure that the tool is non-discriminatory, so doesn't include bias, and that's really the quality of the initial data and the instructions given to the system, which will be key for that.
Mm-hmm. Yeah, right. This will be interesting to see how how the details develop, how perhaps one might be able to, what if one doesn't like the answer that you get from the computer? How does one appeal that, or how does one try to seek a different answer? These are interesting issues, probably to be hacked out over the next 2 years as this regulation is further refined.
Yes, and don't forget that it's so there's this AI regulation, GDPR, but there's also the bulk of consumer protection regulation, which is clearly changing a lot currently in Europe as well. So whenever as a user you're not happy, then you might have rights under these regulations, but this regulation is really more about about safety and regulation of the provision or the putting onto the market of in advance of the putting on the market of these tools. But when it's on the market and as a consumer you suffer damage from that, then you will have the rights under the consumer protection laws to to claim damages or to appeal the decision if that's relevant to the case. Yes.
Right. Thank you. Well, that brings us through these 3 use cases. Why don't we, Arthur, if we could rejoin the flow?
Yes. Good. Okay. Well, thank you, Bertrand and David, for that very broad overview. We know that the EU hopes to make this a global standard. They've done that with GDPR in the privacy context. Environmental laws in some ways for many years have been started in Europe and then gained traction around the world. And of course, Japan always looks at what is happening in Europe and in the US as well, other jurisdictions. But Europe does have, or the EU does have a very significant role to play in the thinking that goes on here in Japan. And so now I'd like to ask Toshio Dokei to give us an update as to where the discussion is now in Japan.
Thank you, Arthur. So let me quickly explain the status of AI policy debate in Japan. As a general policy, I observe that many countries, including Japan, share the same understanding. For example, OECD's AI principles include inclusive growth, sustainable development, and well-being, human-centered values and equity, transparency, accountability, robustness, security, and safety. Japanese government has proposed similar principles, including social principles of human-centric AI issued by Council for Promotion of Integrated Innovation Strategy, established by the cabinet. But the real issue is how to realize these principles. The value of these principles, nobody have any doubt. But the important point is how to implement these principles. The tool to implement these principles could be legally binding legislation, non-legally binding guidances, or self-regulation. Legally binding legislation could be said as rule-based governance model, and non-legally binding guidance as global goal-based governance model. So far, non-legally binding guidance has been a preferred way in the discussions in Japan. The main reason is that rule-based governance could not respond in a timely manner to rapid and complex changes in society, and thus may impede innovation. The policy of Japanese government, I observe, has been present values or goals to be achieved and to formulate guidelines to realize such goals with involvement of multi-stakeholders. The EU's AI regulations, at least for unacceptable AI and high-risk AI, are proposed to be legally binding, I understand. As explained earlier, the EU's proposed AI regulation have great significance in terms of their direct applicability to Japanese companies under certain circumstances, and also they will have a significant impact on the current and future discussion on the general direction of AI regulations in Japan. I think EU's AI regulation will bring a hot debate in Japan as to whether we should introduce legally binding regulation, at least for unacceptable or high-risk AI. Another point from a Japanese law perspective, EU's proposal is about regulation. But I think it would also have an influence as to liability issues. If there is damage related to the use of AI, it will be a matter of responsibility under civil or criminal law of each country. In such cases, for example, the presence or absence of negligence becomes a major issue when considering claims for damages or criminal liability. In the future, if certain AI is governed by EU regulation and damage was caused by such AI, liability issue could be analyzed considering the compliance or non-compliance with the obligations provided by the EU regulation. For example, non-compliance regarding establishment of a risk management system, supervision by natural persons, and conformity assessment procedures may be effectively used as references in the judgment of negligence. Even if such claim is brought before a Japanese court, by a Japanese person against a Japanese company, EU regulation could be considered into by a Japanese judge when the relevant AI system is subject to EU regulation vis-a-vis EU citizen. This is a quite interesting issue which should be discussed further from now. A few observations from my side. Thank you.
Very good. Thank you, Dokei Sensei. So now I'd like to, Ken, now that you've heard what the lawyers have to say, tell us what you have to say as an observer for over many years on these issues.
Great. Thank you, Arthur. I'm happy to. In fact, I found the preceding conversation and analysis absolutely fascinating. I was riveted by and also horrified by what Bertrand had to unveil, and David's case studies were perfect, and Toshio Dokei's excellent way of conceptualizing it and framing it as Japan is looking at these issues. What I'd like to do now is make a few small comments on the implications of the regulation. So next slide, please. So I'm going to look at three different areas. The first one is going to be the impact of the regulation on innovation. The second will be looking at one of the use cases that is in the high risk camp, and that is education. And third, I'll make some general comments on this issue of explainability, transparency, and a concept in the law, or I should say the proposed legislation, for the freedom of errors. Next slide, please. Let's look at this first issue, which is the impact on innovation. As Bertrand has done a very nice job explaining, it has over 80 recitals, 85 articles. It stretches over 100 pages. There's 4 annexes. There's a lot to this. And it is so much that you can imagine that it's only going to be larger corporates that will be able to interact with regulation like this, not smaller companies. But the problem is that what we've seen in technology for the last 50 years with computing technology is that the tools are so democratized, they're inexpensive to use and to become experts on, that you have smaller companies, 1 person, 2 person, 3 person, either companies, people who are not even incorporated, who are experimenting and tinkering, who are at the cutting edge and who are leading the innovation charge. Companies rely on the experimentation that is done by this decentralized cohort of individuals and companies, because as they get bigger, suddenly the larger company buys them and then brings them in. Instant messaging, for example, which was in a sense really popularized by AOL, this is in the 90s, was a small application based on developers in Israel, for example. And this is very commonplace. Most of the people that you work with have large teams of people, mergers and acquisitions people, scouting out young companies in the sub 50 million range to bring into larger companies. But originally they start in the $5,000, $500,000 range. So what will be the implication of a law that restricts the freedom to innovate, create products, and deploy it and get traction for that experimentation of capitalism, if you will, that the startup culture provides? If that's not able to happen in Europe, when it's furnishing the young market or this home market of European consumers, it seems to me that first, Europeans themselves will be at a loss because the artificial intelligence that they will have will be not cutting edge, will be less performant. Secondly, you'll see less growth in that home market. You'll see fewer startups, certainly fewer startups in Europe. And it'll mean that you'll have AI powerhouses outside of Europe that will form. Now, let's look at this from a very practical standpoint. DeepMind, Demis Hassabis, very smart guy, had worked at video games developers when he was a teenager, before he started at Cambridge when he was about 16. Actually, he started at Cambridge when he was at 17. He got admitted, he was so young, he was legally not allowed to start university at that time. He worked, But he'd started companies in the video game area and used artificial intelligence for video games. But when he was going to create what became DeepMind, which is of course probably the world's pioneering AI company today, which beat the world's best Go player, etc., he decided he did not want capital from European venture capitalists. He didn't think that they had the know-how, they didn't have the long time horizons that he wanted. So he went to America to get venture capital. He was very strategic. He got it from Peter Thiel and others. Eventually it was sold to Google. The key thing is that the best and the brightest minds won't stay in Europe. The next future Demis Hassabis won't stay in London. He'll go to Menlo Park. He'll go to Mountain View. He'll actually have to pick up, rather than getting money from them, he will actually go there and create the companies there. So I think this is a risk for the startup ecosystem in Europe. Next slide, please. So let's look at one particular use case and sort of scratch your head and say, hey, is this the way the things should go? And it's in the area of education. Because when I saw that education was considered high risk and therefore had a huge burden of compliance that it had to go through, I scratched my head and I said, that's kind of strange. I mean, there's already a lot of great AI startups in the area of education. What's the problem here? Why is this considered high risk? So let's look at what a use case is. There's a technique called adaptive learning in education, and many companies that are vying for this market. And the idea is that as students do more of their homework and their problem solving on iPads and on computers, you don't have to show everyone the exact same problem set, right? If you've got to do 30 math problems in the next 30 minutes, what you can do is you can actually tailor what their problem set based around how well they answer. So someone who's really good at one part of the multiplication table, but is shaky, maybe good at the 3s and 4s and 5s, but is shaky on the 7s and the 8s, you show them a little bit more of that. As they get better at it, if they have their gaps in their knowledge, say they're doing algebra and they're very good with one part of algebra, but not with others, you can sort of double down on it and give them a little bit more. You can also time things. So you can do a lot of great problems to boost their confidence at the very beginning and the very end of the time and give them the harder stuff in the middle. All of these things are great, and it improves learning, which is great. People can master different skills and then move on. And so the whole class can get better at the same time. The problem, of course, is that if this is considered a high-risk activity, then you're gonna have fewer companies, and it's only gonna be the larger educational providers who are gonna be pioneering this, not smaller companies. So you have to ask yourself, what actually is the problem here? Well, the problem is probably the data that is provided around the students and their performance, because if you know not only how well they're doing at algebra, the data also has the time it took them to answer. It took them the amount of time not only that they have spent on each problem, but the amount of time they do their homework altogether. It could tell you where they're doing their homework. Are they doing their homework 30 minutes before class during recess or at lunch, or are they doing it in the evening? They can do it. Are they doing it at 11 p.m. in the evening, which is too late for them, or they're doing it at 7 o'clock when their parents are looking at them? This is sensitive data, okay? So you can understand why this might be in the high-risk area if we were regulating data, but we're not. We're supposed to be regulating AI. So you have to, again, pose the question, is this the best way to regulate the environment, or are there other regulatory tools, such as data protection laws, not trying to put this through the artificial intelligence funnel to regulate? So next slide, please. So let's think about what this means in terms of explainability, transparency, and the freedom of errors when we think about how we might conceptualize the regulations or the draft regulations overall. The systems that are the most performing are the ones that are so intricate and so elusive technically, needing a lot of fine tuning, not always working, but eventually doing extremely well because you've got lots of parameters that are almost tuned by hand, if you will, that it lacks what's called causality, the idea that we know exactly why the system came to a given conclusion. if I create, if you will, an algorithm, which is what we'll call a statistical or actuarial algorithm, and I tell you what the weightings are, you can, I say, come up with a credit scoring system. If someone knocks on my door and says, hey, how did you get to that answer? You can actually describe to the person the process and the weightings that went into place that got that given answer. You said, well, I took, the amount of money in their bank account and I gave it a weighting of 50% of the model, and I took any the delays they've had in sort of paying off their utility bills, and I gave it a much lower weighting. But with artificial intelligence, it teases out the proper weightings to validate the data you want, the output that you want on its own. And it can also always change. So you actually don't have causality in a way that the regulators would want. And that's actually a feature of the system, not a drawback. Let me give an example of that as well in the time that we have, and why you're looking at a scan of a retina. So there was research in 2018 that wanted to identify whether you could identify the risk of cardiovascular disease through the eye scan. Okay, and so the researchers did that, and they looked at the eye scan and they gave it hundreds of thousands of training data, and they could identify a person's age within 3.5 years. Sounds excellent, very good. They could identify a person's body mass index, better than chance. That was really good as well. They could identify other features that would, high blood pressure, for example, which would lead to cardiovascular disease as well at a very solid performance level. But the interesting thing is when they tried to code and to determine, almost on a lark, if they could identify the gender of the person, it worked at around 97%. The eye and the retina scan could identify whether the person was a male or female at around 97%. And what's interesting is that ophthalmologists and scientists had no idea this was even possible before. If you had asked them whether it could be done, they said, no, there's no theory. We don't know what to look for. It would truly be a guess. So the answer is no, we don't think there's no marker for male or female in the eye, but indeed there is. It was spotted with artificial intelligence, but it was naked to the human eye. It's these sorts of findings that are challenging, and as Arthur pointed out, Henry Kissinger raised this as well. It's challenging us on an epistemological level, right? Because the human being is now, and the mind is no longer the font of all of knowledge. Now, if this is the case, it has implications for how we regulate it, but not in the way that the European Union is trying to regulate it, because the risk is that the European Union's policy is going to stunt the development of this technology. And in one instance, because you don't have explainability. We don't know why this is the case, yet we do know it. So you can imagine that if we can identify that someone has cancer at a far better accuracy than traditional statistical classical models with causality, should we be able to use it? Well, if you're a patient, you would say, yes, of course, please save my life. But if you're a regulator, the answer is no, we're not allowed to do this. So this is going to be a challenge for us in society in terms of what we do and how do we do it. And although I do think the rules will be flexible enough, just a little bit, that you'll have ways to actually make this happen, how many organizations are going to have the wherewithal, the resources, the legal resources, the corporate courage, and the executives with the vision to be willing to wade through it and make it happen? And something that could happen within, say, 4 months will take 4 years. That's the risk, at least. Let me finish by just pointing out, if there's an urge for transparency, that is going to be hard to do because it's not certain we will always be transparent in terms of what we want to achieve. And secondly, that although we want to have a system that is free of errors, that's not how AI systems work, because everything in AI is an inference. The point that the idea that there's an error to it is actually a feature of the system. The clean Boolean world of logic systems of black and white was free of error. But in the Bayesian statistics world of artificial intelligence, you never are free of error. You're always just simply interacting with error and you're making judgments knowing that you always have imperfections. And I'll conclude with this as a thought experiment, which is if you see the rules and what artificial intelligence is defined by the EU, ask yourself, would the same thing be allowed if it was done by a computer without AI, or whether it was being done by a human being, just sort of stroking his or her chin and coming up with an answer? If you frame it that way, suddenly you see some of the shortcomings of this sort of trying to take all of AI as its own entity and regulating it, maybe by what the alternative, and we'll see what other jurisdictions do, but I suspect the alternative, say in an American setting, will be to not try to create regulations around AI itself, but we'll try to have regulations by the sector at the sectorial level, just taking as a given what's already happening and adding the AI component to the regulator's toolbox. With that, thank you very much.
Okay, thank you, Ken, for those thoughts. So now we come to what are we going to do about all this? You know, as Bertrand said, clients are already asking us. You know, we know this regulation is going to come. In fact, it's going to happen. We know that you know, based on experience. So what are we supposed to do today? So I think what we tell them in general is, first of all, you have to understand the principles really which underlie the regulation. That's safety, liability, data protection, privacy, employment issues, anti-discrimination, and of course those sectoral regulations that were mentioned. Many companies do have guidelines already, AI guidelines, but you may have to update those given the content of the proposed regulation. And if you don't have guidelines, you surely ought to look into that right now. Much of this depends upon intent. How is this intended to be used? So you got to be very clear about what you intend to do. And of course, you need to monitor your AI right now. Understand the entire life cycle because you are going to be required, you know, to make changes. And of course, if you're working with a vendor, you want to make sure that you understand what they're doing. One of the big issues, of course, is the black box problem. So you want to try, actually, that's the explainability issue, which is going to be very, very difficult, I think, as Ken has shown. I think in reality, you can only do the best you can, you know, under the circumstances, and you know, hope for the best. But again, pay very close attention to how this regulation is developing. So that now we'd like to turn to a panel discussion. This is open discussion for everyone. Let me. And we'll get to some questions that have come from our audience in a bit. But I want one that did come in earlier was the pharma industry. Obviously, that's an area where AI is being intensely used. Are there any concerns that a pharma company ought to have? Maybe I'll direct that first to David and then to Bertrand to see if you have some thoughts on the pharma industry.
Sure. Thanks, Arthur. Well, this is one industry that is already highly regulated. And of course, for any product to be on the market, it must already have been approved and gone through, you know, the full, you know, clinical trial and regulatory process. And so here, what's interesting is that as of a couple of years ago, we already had the phrase digital health, you know, becoming a term that was used widely. In other words, people were recognizing we had the mashup of two industries, the medical industry and the software industry, coming together. And I guess just in the context, most everyone is thinking that this is going to vastly improve, you know, the situation for everybody, for the patients, for the doctors, for costs, for labor, with more being able to be done given the same labor force. And so there's nothing but you know, highest of hopes for this. But of course, as we've said, this is a new regulation, and it's going to be, apparently, it's going to be added into the medical device regulatory scheme that already exists. And so the companies that are developing these products are, of course, very familiar with the high level of regulation that's required, the requirements for showing your work, showing your data, good record keeping, and demonstrating the safety and accuracy of the devices in order to be marketed. Perhaps the AI regulatory regime is going to, in addition to safety and accuracy, they're going to be adding a layer of perhaps security and trustworthiness on top of what these products are doing. So in general, I don't think, this is going to add to the burden of the companies that are developing the products, but I think it fits in and in essence complements all of the type of work that they're already well familiar with. And in contrast to other companies out there, I don't think anyone who's designed a website has thought they had to go get regulatory approval for their website. But I think the medical industry is obviously well familiar with this, but it's going to increase their burden.
Bertrand, any thoughts on the pharma industry in general?
No, I mean, not really anything to add to what David presented. Clearly, the regulation, the draft AI regulation, will come into play for medical devices embedding any AI system. So, and that will be very similar to what's happening, I think. And so that's really for medical devices. Ken's example of the techniques to the AI technique to identify and analyze images. So that's a standalone. That will be the standalone and that will be also probably a high risk as well because of all what's at stake here in terms of fundamental rights and health and safety and all. So yes, the pharma industry or the healthcare industry at large needs to pay close attention to that regulation.
Right. Well, I think we're quite sure that this is going to affect every industry. Ken, did you have any thought on pharma other than the retina issue?
No, I mean, I would just agree with the sort of the context that with which you say it, which is that if and as David pointed out, you've got these two industries coming together, that it's going to create these inherent tensions that we see.
Okay. So, we have various categories of risk. Again, this is most likely going to happen. So many companies, many of you are going to encounter high-risk situations. This doesn't mean that you should just give up. I think it means you should anticipate that you're going to have a lot of compliance issues. Is this, to Bertrand, is this really too prescriptive? Have they gone too far? Well, they haven't done it yet, but it looks like they are going too far. What do you think?
Well, it's a double side effect. So in a sense, and I think Ken put it in a very accurate way. It's good for big companies. It's probably good for big law as well, in the sense that there will be compliance lawyers for specialize into that and in-house and private practice, and companies and large companies will sort of maybe not benefit from the regulation, but at least will be able to handle the regulation. So it will be workable at some point, and with all the power thinking that everybody will put into it, it will be workable. We will manage, and we will help our clients, and our clients will handle the regulation. Whether it's too much or not enough, that's my personal point of view. I think it's but generally I agree with Ken and his remarks on the sort of the business landscapes that is creating. Clearly, currently, Europe is not on the AI market, or it's very very small on the AI market, especially the sort of the standalone AI system market. So the software piece, that's really the US, Asia, and China in particular, for different purposes. So some of the regulation aims at prohibiting techniques that are developed in somewhere in the world, which we don't want to see in Europe, and that's for good. But it's true that overall innovation might be impaired by the regulation. That's at least my personal point of view. Although, for again, for our clients and for large corporates, that regulation will be just sort of just another layer of compliance. So you have the medical device compliance. When you're talking about financial industry, you already have all the sort of financial regulation compliance burden, and that will just sort of just be another layer on top of that.
Oh, Ken, go ahead.
Yeah, let me just pick up on that, because I think that there's because I think Bertrand, he's in Europe and has been close to the Commission for so long. He sees something and it's wedded into what he's saying, but it needs to be pulled out explicitly. And he wouldn't say it this way, but I'll sort of say it. The Commission views AI as an ingredient to something. You're doing X, now you add AI, and you're transforming it, and now we need to regulate that same thing because of that AI component. It's sort of like saying you've got nuclear radiation. You did it without a nuclear toxic material before. Now you're doing it with these nuclear substances, and we need to regulate it because of that. And maybe talking about it in terms of a toxic substance is correct, because I believe that embedded in the idea of AI that the Commission holds is that this is a tool that is so powerful that there is almost an inherent sense of evil to it. AI is something bad, right? And that AI needs to be sort of tamed, because the inner force of AI will otherwise be run amok and will erode human rights. This, I think, is deeply problematic, because you can reimagine how the world is going to evolve and see it differently. Imagine, instead of all the activities that businesses do, adding an AI to it to improve it, that we shift that around and think of it as an AI duty of care. Okay, what does that mean? Well, this gets back to your earlier question, Arthur, about healthcare and digital health. What instead of, if I go to the hospital and they take care of me, and they decide, instead of having, using whatever technique, that they're basing it on an artificial intelligence answer so that I'm treated better? What if instead they decide to do that because it's a nice thing to do, and it'll lower costs, increase access, and improve care, that I can sue them if they don't use artificial intelligence because they're not giving me the very best treatment, that they actually have a duty to use AI. That if they didn't use it, you'd have to scratch your head. We're thinking now, of course, maybe 10, 20, 30 years out, but that you wouldn't dare sell a elevator that doesn't have artificial intelligence to manage itself, that you wouldn't dare have a website that didn't have artificial intelligence, that you wouldn't dare have a smoke detector that couldn't identify who the person is, not just that there is a person. Or in fact, right now we have light fixtures in offices and we have smoke detectors. We bring them together. Now we've got a smoke detector, but it simply looks for smoke. No, why wouldn't you have a smoke detector that would now look for the occupants, where they are, where they're running to? It's a fire. The firemen need to know where the people are hiding out from the smoke. Maybe we should identify who those people are. Maybe that would be helpful to us. If we think about the evolution of the technology in that way, suddenly, and we reframe it, suddenly the rules don't seem like they fit how the technology is going to be situated in society.
So Bertrand, you get to rebut that, but it segues into a question that we got from one of our participants. So I'm going to read that because it makes it sort of Ken's point very concrete. It says, in AI-based diagnostic tools, intelligent imaging, accelerated data mining, and so on, would the risk assessment be different if the physician intervenes in the diagnosis? Okay, so you got the AI going, and then you have human intervention, which seems to be almost required by the regulation. And then, so is there a difference of risk when AI systems are used as reference versus when they are effectively acting? So sort of as an aid or actually the principal actor? Bertrand.
Thanks for the question. No, I mean, there's a couple of different questions into one. I think the human supervision will be or will not be mandatory, depending really on the system itself and the risk assessment that will be conducted, right? So so it really depends on how the system is built from the very beginning, right? So which data it uses, how does it combat bias and discrimination, and what are the what is the output ultimately? I remember, especially in healthcare situation, having read articles which shows that whenever you're a radiologist and you look at and AI is much better at identifying skin cancer than any qualified doctor working on that specific disease. So will the regulation impose that a human, or will the analysis be different whether a human is involved? Yes, for sure. It will be easier to go through the regulatory hurdles if a human is involved. At the end of the day, is will the service provided, so to speak, be better? Who knows? It really depends on the system. So that would be my answer at this point.
Okay. We have another question from the audience, which I think we have to go back to Bertrand on, as well, as this is a legal question. In connection with AI regulation, what are the prospects for the expansion of strict liability to products which are not currently subject to strict liability? So we're going to have a broadening of strict liability?
So just to be clear, the regulation itself does not deal with, at least my understanding for the moment, it's not dealing with liability between a provider of AI and an end user of AI. Right? It deals with the liability from, let's say, the regulatory liability of the provider towards the regulators. So the commission, the local regulators, national regulators, etc. And that's the penalties that you were talking about earlier. In terms of liability, for the moment, we have it's a different framework, and especially there needs to be some thinking, and it's going to be there's going to be a lot of thinking to articulate this regulation with the safety regulation. And for example, the safety regulation, whenever it's embedded in a product, then you have a strict liability principle, right? I mean, there's a European directive and there's a European regime, at least for what's happening here in Europe. There's that's clearly a strict liability when you put on the market a product which creates a risk of safety, a safety issue, and then there's a chain of responsibility between the producer, the importer, the one who sells that, the pop and mop shop who sold you this item. That will apply to products, including or not AI. So that's for me, that's clear. The other thing is really, do you have a liability, and will that be a strict liability for standalone AI systems? And that is not covered in the regulation for the moment, right? So it's a different story, and that will be discussed. It's either it's a question of safety and there's a risk of physical damage, and we will be back into that kind of strict liability, but if it's different damages, including financial damages or damages linked to discrimination and the like, then it will be much difficult to handle, and we will have a lot of case law and a lot of discussion, legal discussion around that before it gets clear. Yeah.
Thank you. When I was a student at Kyoto University some 40 years ago, there was a discussion in Japan about introducing products liability and strict liability. I want to go back to Dokei Sensei for a minute. If I understood what you were saying, is that it's possible, well, certainly these ideas from Europe are going to be coming to Japan. Would there be a strict liability application of AI in Japan under current law, do you think?
Oh, thank you, Arthur. I basically, I totally agree with Bertrand's answer. So today's topic is EU regulation. It's a regulatory issue, and negligence is a kind of civil matter between the private persons. But as I said earlier, I think when the court decides whether there was a negligence or not, if there is a kind of strict rule applicable to such AI system provider and so on, as a matter of fact, it's not a logical consequence. De facto, that could be a de facto standard. That's what I tried to mention. So it's not a legal consequence, but if there is a very high level requirement for AI system provider, if there is certain damage caused by such AI provider to a certain customer, such civil dispute could be judged by applying low-level proof level of negligence. That, in such a sense, it comes close to strict liability, if we can say. So in a kind of inaccurate word from legal perspective, but yes, I foresee such a thing could happen.
Good, thank you. Okay, we're getting very close to our end time, but I'd like to ask Bertrand one other kind of question. I really think this is really interesting. If you look at Article 5, this talks about subliminal techniques. So it's not only physical harm, but we're talking about your mind. So subliminal techniques that lead to psychological harm. And this is somehow tied to European human rights or universal human rights, if you will. And I don't think anybody disagrees with human rights, but it's interesting to include this kind of concept. I note that in your chart there that things that are called dark patterns are considered to be prohibited uses, and that's interesting. These are things that are kind of basically deceptive and things that are moving you into doing things that you wouldn't normally do. You know, I just heard that. I know those practices. I've heard the term. I hadn't heard the term, but one that I really like is the Roach Motel. You know, is when you get into a site and you can't leave, and it keeps asking you to do different things. I think we've all seen those sort of things. So that's going to be prohibited. How far is it? This seems to me this is going a little bit beyond AI in a way. We're now looking at a very big span of things. What else can happen here? Do you think?
Oh no, I agree with you. It's an attempt to to write down and to put into law what has been identified as problematic in today's world. I think especially, and for example, social networks, and what happened with the influence or so-called influence. I don't know whether that was proven or not, for someone trying to influence the election, especially the U.S. election. So that's clearly an attempt to regulate and to prohibit that. I think we all agree that we should not be influenced that way without knowing that we are being influenced. Whether that will clear the issue or prohibit bad actors to do that. Well, I think asking the questions is a way to answer it. If they're bad actors, then they will still would be bad actors. So yes, so the way I see that as a practical consequence in a way is that there are good actors and they will try to abide by the regulation, and there's the big corporates and there are clients, but there will remain bad actors trying to do that to and not only the European people, but every people in the world, as far as they have an interest in doing that. So and the regulation will not really clear that. So but we'll put regulatory burden on corporates. maybe also, and I think that's sort of the idea behind that. Is that the Commission wants to make sure that big actors will play it well, so that they prohibit bad actors to do that, because in a sense the Commission cannot do it themselves, right? So it's a sort of also so sort of putting the burden of defending those rights to the good actors, and in a way it's another debate that we can have in another place, but it also worries me in the sense that it means that the public bodies cannot do that, and they're sort of outsourcing that to private bodies and corporates. But that's another debate. Interesting.
Well, we could talk about all of these issues for much longer. I'm going to give Ken the last word.
A very small one, which is simply, remember, this is draft legislation. And typically at this stage, the Commission has a grab bag of a wish list of all the things they'd like, and the final version gets tapered down a little bit. But the country that typically clipped the wings of the ambition of the Commission was Britain. And now Britain is not even part of the EU. So the one entity that usually sort of tempered their wish list and brought it down to make it a little bit more practical and pragmatic isn't around anymore to do that. So who knows what the final version will look like.
Okay. Well, we've come to our appointed time, so I want to thank all of our panelists, and especially thank our audience for signing up. We're going to continue talking about AI and the various ramifications for your business, over the next few months. So please stay tuned. We'll let you know when our next webinar is. And again, thank you so much.